Ladies and gentlemen, we gather in rooms like these, and many others repeat these rituals all over the country, with the understanding that it's a sanctuary where justices of the peace and well-reasoned peers gather to decide legitimate and difficult questions, questions of innocence and guilt. And we do this to keep each other honest and fair. We do it to narrow the gap between the promises of our ideals and the realities of our practices. And we do it out of an unyielding faith in human decency. Now, the most powerful person in this room is not myself, it's not opposing counsel, it's not the defendant, it's not any of the witnesses who were called, and it's not even any of the concerned members of the public who have come to watch these proceedings. It's you, gentlemen of the jury. But what the defense has done today is come forward and not ask that you honor the time-bound tradition and the responsibility that we just discussed, but that you ruin it. You see, as uncomfortable for the defense as the facts may be, what we now know is that the defendant broke the law and is now doing everything possible to blame everyone but herself, up to and including those who protect the law, just like yourself. And see, that's a shame. It's shameful to imagine that there's a very real outcome here in which the defense's client is exempted from the very rules that we all agree to follow simply by engaging in a practice as old as time, blame shifting, the practice of desperation, the practice of the guilty. But let's take a step back to early 2014. The Midland State Gambling Commission announces that it will begin accepting proposals for a new casino license. And this is a relatively rare event in the context of the full history of the state of Midlands. And for weeks, rumors buzz that the defendant will apply. Why? Not because the defendant is a burgeoning entrepreneur, but because the defendant has a reputation of being an empire builder, somebody used to getting her way. And in this case, her way is to be the first person in state history to own 2 casinos, a very profitable, very high-profile goal. And so, ultimately, it was the defendant's greed and vanity that was her downfall. She placed a direct call to a voting member of the Midland State Gambling Commission, Chase Covington, and the first words out of her mouth on February 13th, because the timeline is important, is that she was willing to grease the wheels to get her proposal through. That's not exactly an everyday turn of phrase for me. And so in the following weeks, an officer of the law scheduled a series of meetings between the defendant and Chase Covington to see just how far the defendant would go to grease the wheels, which ultimately coaxed the crime out of the criminal. Because then, on April 13th, the defendant, acting of her own accord, picked up a pen and offered a $250,000 bribe to a voting member of the commission. And it worked, because she did get her casino, but then the house of cards started crumbling around her, and only then did she bring it to the attention of the authorities. Only after she had been caught committing this crime did it become someone else's fault. Now, we have to have proven this to you beyond a reasonable doubt, because we're the prosecution in today's case, and we accept that burden because we know we've reached it. And what that burden means is that we're confident that at the end of today's trial, not a single reasonable doubt will remain in your mind that the defendant committed this crime. So what exactly is the crime? In legal terms, the crime is called bribery, and to prove it to you today, in today's case, we simply must prove this concept of predisposition. And if you find that the defendant was predisposed, which just means that she would have committed the crime whether or not anyone else was involved, then you must find her guilty. And when making that decision, you must consider things like, whose idea was the crime? Was the defendant repeatedly pressured? Was the defendant resistant? Did the defendant participate? And does the defendant have a history of committing similar crimes? But why is it just that? In this case about casinos and money and bribery and napkins, why is it that we have to talk about predisposition? Well, mostly it's because the defense is offering what's known as an affirmative defense, which really just means that they're admitting that the defendant did it, but claiming there's some other reason why she's still innocent. In this case, that reason is that they claim that the defendant was induced or repeatedly pressured by a law enforcement officer. And they haven't proved that. They haven't proved it because they can't, and they can't because the body of evidence simply doesn't support it. But don't just take my word for it, let's hear from the witnesses. What do the witnesses have to say about it? Well, we're going to split it up into the 2 concepts relevant to today's case, and that is the first one, predisposition, and the second one, this concept of inducement or repeated pressure. Let's talk first about predisposition. Keep in mind, predisposition has to come down to whose idea was it, Does the person have a history of the crime? Well, this transcript of the March 31st meeting that the defense made central to their case, it was brought out on 4 of the 6 witnesses that you heard from today. The defendant took the stand and admitted that the first person in this transcript to talk about the fact that Chase Covington was the swing vote on the commission, that Chase Covington was the person that they had to talk to. The first person to mention that was the defendant. She made it a topic of conversation. She made Chase Covington the focus. She's the one who wanted to talk about Chase Covington. You heard from Danny Hoy and Corey Hyde, who told you that prior to this meeting, the April 13th meeting where the defendant alleges she was so pressured that she committed this felony, she was the one poking around about the security protocol, not only for the meeting, but also for the casino. She's the one that wanted to have unprecedented security measures. She's the one who wanted to have her own personal assistant, who was aware of the meeting, swept for some reason. She was the one who asked about blind spots in the casino, conveniently, of course, the blind spot in which she met with Chase Covington after the meeting. She was the one. Now, you also heard from the defendant's mouth that she has a history of finding herself in issues and then using money as the route to solve those issues. On 2 separate occasions, we heard that she had an issue not only with the Midland Zoning Commission, but also with a federal judge, and in those cases, she made sizable contributions to their political campaigns, and her problems magically disappeared. Sounds an awful lot like this case. So what about inducement? Was the defendant induced? Well, really that comes down to, in today's case, this battle of experts that you heard. You had one expert, Dr. Lorien, you had another expert, Dr. Warren. So I'm going to start with Dr. Lorien. Dr. Lorien took the stand, and the first thing she told you before getting into any of her conclusions was that her conclusions are not based on fact. They are grounded in opinion only. But even if you don't buy that it's opinion only, the only thing that she told you was that she takes issue with the procedures that Officer Keenan followed in the commission of this investigation. Not the actual actions of Mickey Keenan in her interactions with any of the subjects, which of course is the only way to prove inducement, but just the procedural matters. What kind of records were kept? Now, on the other hand, you had Dr. Warren, whose conclusions were grounded in fact, who told you conclusively that inducement did not happen. She reviewed this March 31st transcript, which was so important to defense counsel, and concluded no inducement happened. Now, defense counsel made a big deal out of the fact that there were 4 conversational strategies found. Well, really 3.5, because one of them was questionable. But what that means is that 4 or 3.5 out of 10 were present. That's 35 or 40% of conversational strategies necessary to conclude inducement. Ladies and gentlemen, not only is that not enough to conclude inducement, it's not even enough to reach the burden of preponderance of the evidence, which has to be 51% convinced. Even mathematically, the evidence doesn't stack up. But the most compelling evidence came from the defendant herself when she took the stand, and I want to make sure I get this quote right. She said that I had to offer the bribe to Chase Covington because otherwise the proposal wouldn't go through. So during your deliberations, gentlemen of the jury, always keep in mind the fact that the defendant took the stand and admitted to the crime in open court. Even if you don't buy the evidence that was levied against her, which was substantial, she took the stand and said, I had to make the proposal go through. She bribed a member of the commission to make her proposal go through. It is an admission of guilt in open court. And we know that she's guilty because she felt at no time like it was necessary to go to the police. Of course she didn't want to go to the police because she was guilty, and she knows she's guilty, and she's guilty now. Find the defendant guilty of bribery, not because you know that she did it, but because she knows that she did it. Thank you.